sorry, I do apologize for the crime that I committed, but I'm not pleading guilty.
He's got a funny way of showing how sorry he is by the way he's acting in jail.
You're smoking an average of 5 marijuana cigars a day. You're making bad choices all the way around. Plus, you're high as a kite. Shooting to death of a person. How many write-ups have you had? 55. Over 30 pages. I've never seen such a thing. You were looking at up to life in prison, which I can't even imagine for a 17-year-old.
We've got one of the most entitled brats in court today. He's actually trying to argue for probation after killing someone, and I don't say this lightly. This has to be one of the most delusional things I've ever heard. You won't believe the arguments he makes, and you won't believe the things he's already done before this. This guy's rap sheet is longer than the dictionary, and somehow he thinks he deserves a free pass. The wild part is, he's not even shy about it. He's bold, smug, and acting like the system owes him something. It's like watching someone who failed the test, but still argues with the teacher for an A. So here's the big question. If this is what justice is up against, should anyone like him ever walk free? Let's go ahead and dive in.
The agreement is whatever sentence shall not exceed a cap of 30 years imprisonment. So we are looking at no less than 5 up to 30 years in prison. A regular probation is not an option. And the other thing would be deferred, I guess, or unadjudicated probation. Is that even an option? That's not even an option. It's all straight, flat time. And how old were you at the date of this event? You're now 20, right? 20 years of age now?
Yes, sir.
Okay. All right. State, do you wish to go first? You can go first and last.
Judge, this case originally had 2 people charged. There was an Isaiah Brewer and Mr. McQueen were charged. This was supposed to be just a group of people meeting for a fist fight. And as usual, when a fist fight was about to start, somebody pulls out guns. In this case, the question was always been whether or not there was a self-defense because the defendant has claimed and still claims today in his pre-sentence report that the victim pulled a gun and pointed it at him and his family, and so he was just defending his family. I think he pled is because when we came up for trial, the co-defendant had agreed to testify and was going to testify to the fact that the statement he gave the police was that the victim, while the victim did have a gun, the victim never pointed it at the defendant or any of the family members. And there was also another sister of the defendant, I believe, or a witness that was with the group with the defendant who also would testify that a gun was never pointed at the defendant or any of the family members. That the minute the argument started, the co-defendant said that the victim had pulled out a gun to point it up in the air to make everybody get away. And that's when Mr. Algero here, McQueen, started shooting and shot about, I forget how many bullets there were fired, but pretty much unloaded his gun, shooting the victim. The victim, when he was falling down, then returned fire to shoot back at them, hitting a car, and then did not wound anyone that I know of. This was, once again, one of those shootouts that we have in Beaumont where, unfortunately, someone got killed. And it's all these youngsters running around with guns. And this one, I don't understand why they had to go meet up at the victims across from the victim's sister's house. She claims, the victim's sister claims that they were chasing her brother and were going to gun him down, and that he never stood a chance, that she heard the shots. She came outside and they were driving away and still shooting out the back of the car. So all this adds up to, we do know that Mr. McQueen, when the police arrested him, he did admit that he's the one that shot and killed the victim. I've given him credit for that admission, for at least owning up to it, and also because there was some other activity out there that was fighting, and I capped it at 30. I think that looking at his history, not only his prior juvenile history, but looking at his history since he's been in jail, you've got a copy, I think, of all the jail incidents, and he hasn't really shown that even if he was wanting to straighten out his life or try to convince the court that he was very remorseful for what he did. His incidents in jail show that he just has no respect for anything or anyone. And so we would ask for the 30 years.
You can literally see the look of defeat stamped on the defendant's face. He knows he's done, and the scary part is that the only person he can blame is himself. His actions, not bad luck, not some setup, just his own decisions brought him here today. It's crazy how one split-second choice can rewrite your entire life, and now at just 20 years old, his future is already locked away. There's no sympathy left here, especially since he's shown zero respect for anybody else. If you take a life, don't expect a jury or a judge to have mercy. It's that simple. And let's be honest, there's no self-defense claim hiding in this mess. He meant exactly what he did. The justice system usually has to weigh intent versus accident, but here the intent is clear as day. At this point, his story reads like a cautionary tale written in permanent marker. You can almost feel the judge's patience wearing thin just by looking at him. Honestly, I don't see this ending well for him at all. The maximum penalty seems almost guaranteed, but what do you think? Drop it in the comments. Should the judge max him out, or is there any sliver of redemption left?
All right, Mr. Kelly.
Thank you, Your Honor. Number of things that are important in this PSI. None, and Mr. Riley, who I think is in the courtroom today, judges who composed this for us for the court. But one of the things that stands out maybe a little bit more than the others is at the beginning of Mr. McQueen's social and personal history, which of course is on page 4 and it's the second line. I know the court has seen this already, that Al's dad was Al Drew McQueen Sr. and that he left this earth in 2017. My math is right. Al was 12 at the time when he lost his dad. I've thought about that through the course of this case, and certainly since we got this.
What year was that?
2017.
He lost. Okay.
And more.
What was the date? March 7th, you said? What was the date he lost his dad?
2017. The month is not.
Okay.
And I've thought about it more since we got this report. Maybe not fair to put myself in his shoes, but as a human being, you can't help that. And when I was 12, my dad was my hero. What your life looks like had you been born into different circumstances or had different circumstances. And it's not a completely apt comparison, but hopefully those of us that hard cases in here every day can at least have an awareness of that. And one of the reasons that it's important is that the court has looked at the pages before that, and Mr. Laird is correct. And he notes some of the issues that Al had as a juvenile, and they line up with those same dates. That's where this thing kind of got off the rails a little bit. Mr. Laird and I have that conversation. The court says it on the record a ton, and whether you want to call it science, whatever it is, those two things go together. There's zero question about that. Those two things go together, and those events, Mr. McQueen Sr. leaving the earth and the beginning of these issues, they're not excuses. And Al's going to talk in a minute. They're not excuses, but if we're going to say that a pre-sentence report is at least more than a snapshot of a background, then we have to be fair enough to take those things into account. One of the other things that we mentioned, and the court looked at our letters that are included in our memo to the court, but one of the other things that we mentioned is it's not to devalue anything, but this is, and again, I think Mr. Laird said it exactly accurately. It is tragic in the classical sense that life could be treated in such a way. And one of the questions that this court asks more often than it probably wants to is, how do you bring a life back? And you can't. And so then the question becomes, what is just, what is appropriate for that family, for the Edwards family, but also Al's the one standing in front of the court. So what then is appropriate for him to have accepted responsibility? I would say supposedly saved a number of different folks, a trial, which would only be a rehearing of those facts of that day. And some of those folks are here today. Some are Al's family members and some are other folks. But what then is appropriate? I can't tell what is more disheartening as somebody, again, for all of us that work on these kind of cases every day. What's more disheartening is the case where you look backwards and you see a number of criminal episodes that of course culminate in a murder, and we all look at each other and say, well, that story wrote itself. Or somebody who hasn't even started life yet and is here already. No excuses, but they paint the rest of the picture, and they have to be accounted for. I know that the state's position is that some of the credit is in the cap, and I don't disagree with that. We ask the court to take into account everything that we put into that memo. The folks that wrote letters on his behalf to the court, I can't imagine angst that it causes a mother or a grandmother to have to write a letter to a court in this situation, in the same way that the Edwards family has been dealing with loss for the last 3 years. So too will these folks, in a different way and less permanent. Wouldn't compare those two things. They are facts, but both of those things can be true. We ask the court today, in light of all that, for measured leniency.
So here comes the defense's angle. The defendant lost his dad when he was a kid, and listen, I'm not minimizing that. Losing a parent is brutal, but here's the problem. Millions of people already grow up with tragedy, and they don't go out and kill someone. Pain doesn't justify creating more pain. The idea that a tough childhood can excuse murder is one of the weakest defenses I've seen in a long time. And legally, judges see right through this, because hardship isn't a defense. At best, it's a weak attempt at mitigation during sentencing. Everyone in that courtroom knows that his upbringing isn't on trial. His actions are. If anything, bringing it up makes him look like he's ducking accountability, and honestly, if that's the best argument his lawyers have, it's not going to carry him anywhere but straight to prison.
Your Honor, I am sorry. I do apologize for the crime that I committed, but I am not pleading guilty because of someone wanting to testify. It is not scary. I'm pleading guilty because I know I was wrong and that I could have handled the situation different. I'm asking for not for the 30, not only for me, but for my family too. I understand what I did was not right. I can't change someone else's mind of how they want to handle the situation. I did probably what anybody else would do if their family was in a situation like that.
He's got a funny way of showing how sorry he is by the way he's acting in jail. Totally disrespecting people, not following rules, and just wanting it his way. And I think that's been his life. When you look at him, all of his juvenile history, the way that when he gets in trouble, he gets probation, and then he messes up. He violates the court order several times on just a misdemeanor criminal trespassers. There's 1, 2, 3, 4, 5 violations, and that one just in 2018, and he gets probation again for another. And he's got more violations, and he gets a terroristic threat. He's got more violations, and all he does is he just does it his way, and then thinks saying I'm sorry is okay, and it's not. You got somebody that's deceased that's not coming back by his making a bad decision. Was not a bad decision. It's a terrible, horrible crime that he committed. So we would ask for the 30.
Punishment generally is based upon criminal history and the circumstances of the crime. Also, the court looks at the person's environment, their lifestyle, their choices that they have made in their life. And all of those are compiled very well in a pre-sentence report that the probation office fixes up. Juvenile history that begins in 2017 with being a runaway, then criminal trespass, robbery, runaway, criminal trespass crimes, terroristic threat, criminal trespass, theft, unauthorized use of a motor vehicle. All of these are, even through 2020, unauthorized use of a motor vehicle, evading arrest or detention, several pages. And then this event occurs on May 28th when you're 17. The pre-sentence report also states that not only do you have a consistent commission of crimes and illegal acts, but those also include you're smoking an average of 5 marijuana cigars a day. This says from the day from 16 years of age until May 28th when this event happens. I mean, daily. So you're making bad choices all the way around. Plus, you're high as a kite consistently. The shooting to death of a person, a large juvenile criminal history. There were inconsistencies in your accounts when you were talking to law enforcement and the investigators about what happened here. This was a shooting that occurred from a plan to meet with people to air out grievances in a way that wasn't going to be using I thought and a peaceful means. Everybody seems to have a gun, and everybody is you. Certainly, according to this report, it suggests that you had planned to use a gun, and this doesn't show anything spontaneous. And the self-defense claim is undermined right and left by the facts that are shown in the reports. Then, after this happens, you dispose of your cell phone, clothing, things that you're doing to avoid detection and to try to prevent the trail of the event leading to you, which is consciousness of guilt. And you're placed in jail. How many write-ups have you had for jail behavior problems? I'm going to give you a hint. I'm looking at over 30 pages. I've never seen such a thing by anyone before me with that many jail pages of jail problems. But the way you handled all of this while you were waiting is as irresponsible as you handled the event. It shows such a lack of remorse. It's as though you don't want to do the right thing. Do you know how many write-ups you've had? 55. I've never seen that many here in 18 and a half years. Isn't good. It isn't good. And here you are at 17 and you're taking a life.
I don't know about you guys, but I'm definitely not doing what he did. I would have handled things very differently, starting with not killing someone. And here's where it gets tricky. Can we even believe him when he says he's sorry? To me, it feels like he's just throwing out words to soften the blow, because if he truly felt remorse, he wouldn't still be acting like the tough guy behind bars. Imagine being disrespectful while you're waiting for sentencing. Talk about playing yourself. When the state read off his rap sheet, you could see his chances collapse in real time. This isn't a man on the edge of redemption. This is someone stacking bad decision after bad decision. Judges don't fall for theatrics, and they definitely don't fall for crocodile tears. At the end of the day, this wasn't about peace, it was straight up violence, and the system is about to return the favor.
I've read some letters on your behalf from, it looks like families and acquaintances. What they say about you, though, is completely different than what this report shows, which are the bad things. You can't be Dr. Jekyll and Mr. Hyde. You can't live, you can, but it's like dancing on a razor blade. It's not safe and it always leads to destruction. But you can't be good and bad. You got to make a choice. Your choices have to be good. This was tragic. And now, with all of this, we have a life that was lost that you took, that you're going to have to carry the rest of your life. But I don't read anything here at the end. I don't hear anything about, I'm sorry this happened. I don't see it anywhere. And I guess I'm not surprised, but I don't see it at all. And really, you're admitting you did this and somebody was killed and a life was taken. One of God's creatures was taken, but it's not much of regret. No sign of it whatsoever. Certainly, you hadn't shown that you wanted make the right choices since you've been in jail. And Mr. Kelly is a great lawyer and is trying hard, but it's hard. It's hard to manufacture help for you when you're not wanting to help yourself by making the right decisions. And then here we are. And probation office kind of sums it up in the the report, that any factors of leniency are may be outweighed by the gravity of the murder, your extensive juvenile record, your ongoing behavioral issues in jail, and the actions surrounding the crime which indicate consciousness of guilt. And the court should consider these factors as well as others presented by the parties. And you were looking at up to life in prison, which I can't even imagine for a 17-year-old. Anything else to add by anybody?
No.
Or anything, Mr. McQueen, you want to say? No? No, sir. All right, I am going to follow this agreement, and that he will be sentenced within this. I now find you guilty beyond a reasonable doubt in this case. I'm following this agreement. You were hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 30 years imprisonment as agreed as the cap in this case. You will be given credit for all time you have served, and the judgment shall reflect that a deadly weapon, namely a firearm, was used in the commission of the offense. All right. Good luck to you, and I hope you live better.
This guy is getting exactly what he deserves. The judge didn't buy a single ounce of his fake apologies, and honestly, why should they? He couldn't even muster up the basic decency to say he was sorry, which tells you everything about where his head's at. You can't plead not guilty and then go completely silent when asked if you have something to say. It's like waving a giant flag that says, yeah, I did it. And now he better get used to the sound of metal doors clanging shut, because cell blocks are about to become home. The legal system isn't perfect, but one thing it does well is punish arrogance wrapped in violence. And here's a wild legal fact. In cases like this, silence at sentencing can actually hurt you more than saying the wrong thing. It signals zero remorse to the court. Do you agree with the final decision, or do you think he should have been hit even harder? Maybe with life behind bars? Let me know in the comments. Thank you so much for watching. Don't forget to like and subscribe, and I'll catch you in the next one.